Today's story is about terminal illness, personal choice, and a question that divided America. Does a person have a constitutional right to end their own life with a doctor's help? The year was 1997. In the state of Washington, helping someone commit suicide was a crime. Doctors could treat patients, ease their pain, and provide comfort, but they could not legally prescribe medication for the purpose of ending a patient's life. A group of doctors, terminally ill patients, and others challenged the law. Their argument was simple. They said that some patients were suffering from painful and incurable illnesses. These patients were mentally competent and knew they were dying. If a person has the right to make decisions about their own medical care, shouldn't they also have the right to choose the timing and manner of their death? The challengers argued that the Constitution protected this personal liberty. The state of Washington disagreed. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. The state argued that legalizing physician-assisted suicide could put vulnerable people at risk. Elderly patients, disabled individuals, or those facing depression might feel pressure to end their lives. The state also argued that preserving human life was an important government interest. The case eventually reached the United States Supreme Court. The question before the court was whether the Constitution created a fundamental right to physician-assisted suicide. In an unanimous 9-0 decision, the Supreme Court ruled that it did not. The court held that the Constitution does not guarantee a right to physician-assisted suicide. States could continue to prohibit the practice if they chose to do so. However, the court also left the issue largely in the hands of state governments. Over time, some states would decide to allow physician-assisted dying under carefully regulated circumstances, while others would continue to ban it. The decision drew an important distinction. A patient may have the right to refuse medical treatment, but that does not necessarily mean a doctor has the right to actively help end a patient's life. The debate continues today, but Washington versus Glucksberg remains one of the most important cases on end-of-life decisions in American law. And that's the case of Washington versus Glucksberg. Thank you for watching. If you enjoy this story, follow along for more. See you on the next one.